Estate planning can be a hard conversation to start. It's right up there with updating your insurance and finally cleaning out that drawer full of old phone chargers. It's one of those things everyone agrees is important, but many people keep putting it off. And with the recent tax changes, things seem more confusing than ever. The problem is that when estate planning goes wrong, the consequences can be deeply personal. Families can stop speaking, siblings end up in court, vulnerable people get left unprotected, and the people left behind are forced to make difficult decisions without any clear guidance. The irony is that most of these problems are entirely avoidable. So today we're talking about estate planning. Not just who gets what, but how to make life easier for the people you care about. And that's today on Money and a Good Life. My name's Stephanie Coombs, and sadly, I'm here solo. Today, Ryan is off sick, which is unfortunate for him and also unfortunate for me, but that's okay because today we're joined by Susan Bonnici. She is the principal estate planning lawyer at Aitken Partners. Susan has spent her entire legal career working in estates and trusts, helping families navigate everything from straightforward wills to highly complex estate planning. Susan, welcome to the show.
Thank you so much, Steph.
I'm sorry that Ryan isn't here with both of us today, but he's all tucked up in bed and having a nice little sleep, I hope.
Sending him well wishes. Hope you feel better soon, Ryan.
Yes, indeed. Now, obviously one of the biggest bits of news recently is there's been a lot of taxation changes, and the budget has also gifted us a few interesting changes around the taxation of trusts. What should people be paying attention to right now?
Well, the first thing to think about is that we actually don't know the details of the budget yet. We're not going to know anything until the legislation gets through and we get to read what's in the legislation. So while we have some announcements which have sent people into a bit of a spiral about what it means for tax and trusts and small businesses and how everybody has their companies and other entities established, it is important not to panic and wait and see what the details are. There are some things, though, that we can be pretty sure about. And one is that one of the big announcements about trusts is the government has announced that part of the budget will include a minimum 30% tax on all income distributions from discretionary trusts. Now, initially that was to apply to all discretionary trusts, whether they be inter vivos family trusts created during someone's lifetime, or testamentary trusts, which are trusts that are created through somebody's will. That created a lot of concern in the legal community, with our clients, for people who have written wills with testamentary trusts involved, because that's a huge change to how people have structured their inheritances.
For someone like me who is a real dunce on this stuff, what is a testamentary trust?
Okay, so a testamentary trust is a trust that somebody writes into their will to hold an entitlement for a beneficiary. So instead of those funds going to the beneficiary directly into their personal name, a discretionary trust is set up for them, and that has significant advantages. So because that beneficiary isn't the legal owner of those assets, the trust is the legal owner, that means that there's some asset protection built in. And for many clients, that's the main reason for setting it up. That means that if the beneficiary ever goes bankrupt, if they're a director of a company and that company goes bust and they've got creditors coming after them, if they go through a divorce, those assets that are in that trust, because they're not in their personal name, have some protection. The other reason why people historically have set up testamentary trusts is for tax planning. So if I inherit $1 million, say, into my personal name, that goes into my bank account. I have to pay tax on any income earned at my marginal tax rates. If it goes into a trust, it still earns interest, but I can pay that interest out, that income out, to my children, to my partner, to other people on a lower tax rate than me, and that can be some effective tax planning for the beneficiary. One of the reasons as well why people have been setting these testamentary trusts up is to hold inheritances for vulnerable or vulnerable beneficiaries or people who are not able to manage the finances for themselves. So there's a few different reasons for setting up testamentary trusts. And one encouraging thing that was released just last week is that the Treasurer and the Prime Minister gave an update on the budget measures, which said that testamentary trusts are now going to be excluded. So that's a huge relief for clients who have included testamentary trusts in their wills for whatever reason they might have set that up. And while there is still some detail to be announced around how that will take effect in the budget, that is an encouraging sign, at least, to see that they've come around to excluding testamentary trusts.
You must have gotten a lot of panicked phone calls.
Oh, we
I bet
did.
your phone was running hot when that happened.
We did. I think between us and financial advisors and accountants, we were on the phone a lot after the budget was announced, with people wondering, how do I need to rewrite my will? Do I need to change, restructure my family trust? What should I be doing? And
you can't answer that at that point because you didn't have the details. So you had to say, wait and see. But that's stressful if you've got, a will in place and you never know. You want that to be watertight.
Yeah, that's right. But it is encouraging, I think, things like this when they come out in the media, it's a good time for people to actually look at their documents, because a lot of people that I know write their will and then put it in a drawer and forget about it. Something like this comes around and it gets people talking and it encourages them to go and look at their will and say, is this actually still appropriate? Does this meet the objectives that I want?
Yeah.
So that's sort of a good thing, I think.
And let's talk about the other kind of trusts, which do look, though we don't have the detail, as though they might be being taxed. What's happening there?
It does look like the 30% minimum tax on income distributions will stand for family trusts. So people will need to look at, and speak to a financial advisor. Obviously, if your clients have Tribeca, go and call your people there and just see whether that's what impact that's going to be. So that will mean looking at who you're distributing to from your family trust, whether you need to change that. I know that people with bucket companies who they make distributions to from their family trust, that'll be a big area that's been impacted by this budget measure. So thinking about how you use the family trust, if you need to change that as a result of the budget, will be a big factor in the coming years.
When's the time to start actually taking action? Is it when the detail's been released, or should you now be really paying attention to what's being released in the news?
I think, start paying attention now, start those conversations, look at how you use these structures. Just start thinking about it, and then you'll be prepared, I guess, when the details come out in the budget and ready to take some action.
I think it always pays, right, to just pay attention to what's happening with your money because, as I said in the introduction, these are things that we put off. But maybe as you said, this is a good time to wake up a little bit.
Exactly.
So you've worked in this area, obviously, in the family estate planning since 2012. And for most people, when they hear estate planning, they obviously think that there's a lot of paperwork. And this, I'm sorry to say this, but I would have thought that this would be quite a dry area to work in. Prove me wrong. What is it about this job that you like doing?
I really like working in estate planning. Unfortunately, it's an area that's going to touch on all of us at some point, whether that's we lose somebody that we love or eventually when we pass away ourselves. So it's unavoidable. And it gives me a real sense of satisfaction to walk somebody through the process of getting those plans in order. People feel so much relief after they've come to see me when they know that they've thought through how their family is going to be looked after, their wealth is going to be taken care of. Everything that they've worked so hard to accumulate during their lifetime is going to be dealt with in accordance with their wishes, whether that's looking after their family members, making distributions to charities that are important to them, whatever it is that that client wants to achieve, it's really important that gets documented because otherwise you lose control of all of that wealth and anything that you've accumulated during your lifetime, you should be the one to say what happens to that. So it's very satisfying to help somebody with that process.
And it's more than just deciding who gets what, my grandkids get the old furniture and, the other grandkids get the house or whatever. Like it is a little bit more complex than that, isn't it?
It's a lot more than that. So when I sit down with clients, we look at, who, yes, a big part of it is who gets what, but also how that's structured. Are there beneficiaries with different needs who would need some sort of trust to help them protect their inheritance? Who do you want to put in control of the will or any other entities that you might have established? What do you want to happen if you lose capacity during your lifetime? So, we've got an ageing population now. Dementia is a big thing. As part of estate planning, we look at powers of attorney and who you'd appoint to make decisions for you if you're not able to act for yourself. So it really is a lot more holistic than just who gets what. It's thinking about what you own, who you want to manage that, who you want to take care of you, who you want to take care of your loved ones. And it's a very personal story that I go through with each client to work out what's their objectives are.
And when you're dealing with families, right, you're dealing with a lot of complex emotions, I'm sure, and very deep, complex family law.
Yeah.
It's like, oh, why we don't talk to aunt so-and-so and, why this person gets this and that. How much of this is actually not working in the law and it's actually having to unpick people's very complex familial lives?
It is a lot of that. Some of my client meetings are a bit like counselling sessions where I hear about the whole family history and, as you said, who talks to who doesn't talk to who. And, sometimes it can be quite sad. Parents who have been estranged from their children for many years. There's every family is unique. There's black sheep in every family or, complicated dynamics. Blended families are a big thing as well that I advise on quite a bit. There's a lot of complex relationships at play and it can become a bit of a, whenever you have complex relationships, money and death, tax, all of these, there's a lot of fuel that can be put on those fires. So working out how to manage that and try to keep the family intact
which
through that.
Which is actually, because I know even in my family, like a couple of generations back, my grandmother's family, there was a split over who got a house, and that perseveres to this day. Like it was, my grandmother's siblings don't talk to each other. Every family, somewhere there is a family that got split up through a will. So it must be hard for you because you have to honour the client's wish, whereas I hate that person, I don't want them to see a cent.
Yeah.
But that's going to maybe be contested in court or something as well. So you have to advise through that.
Yeah. So that's exactly right. So the best thing that I can do in those circumstances is to advise the client to say, these are the risks. Obviously, I hear what you're saying. I understand that you don't want to leave a cent to your son that you haven't spoken to for 20 years. I get that. You're totally entitled to put that into your will. The will is your document. You can record whatever you want in there, but I have to tell you the risks of writing a will in that way and what we can do to mitigate those risks. So, if you do exclude a child completely, there's a huge risk that child will come and challenge the estate and likely be successful in challenging the estate. So what can we do to reduce that risk and try to preserve what you want to achieve in your estate planning? It's a complicated line. Some clients that I see will say, okay, we'll do whatever we need to do to avoid the risk. Some people will stick to their guns and be like, I don't care, I'll be dead. They can fight over it, whatever.
No.
So I see all types of reactions.
What do you do? What do you do when you're dealing with someone where you're like, I can see that this is going to be a landmine for someone in the future? Do you just have to honour their wishes and?
Well, sometimes you do. There are things that we can do to try to avoid the risk of a will dispute. But when you get some stubborn clients who dig their heels in and say, this is just the way I want it and they can fight over it, that's what I have to do. And that's their right.
It is their right. I mean, it is their possessions. But it's funny. If you don't want that, and I think that there are all kinds of people in this world, aren't they? And some people
Yeah.
do want that. They probably enjoy the idea of conflict or whatever, and everyone is entitled to walk their own path. But if you don't want to have your family members squabbling over what you left behind, how is it best for you to plan your estate?
Yeah, so when it comes to people challenging an estate, you have to be aware that it's only the assets that you own in your personal name that will form part of your estate when you die. So that asset pool of assets that you own, that's all that can be fought over at the end of the day. So one thing that people do where there is a risk of an estate dispute is they can try to reduce those assets in their personal name. And some things that people do to achieve that might be giving money away while they're still alive. If I give $100,000 to two of my children, excluding the third, while I'm alive, no one can question that. At least in Victoria. New South Wales is a different story.
Yeah, right. Oh, really?
Yeah. In New South Wales, there are different laws about what will form part of your estate.
Yeah, right. Interesting.
So, yeah, there's different things people do to try to reduce the amount of assets in their name when they die. Giving things away while they're alive is one thing. Setting up some different entities like family trusts or moving assets into joint names is also a strategy. Putting more money into super. Anything that you can do to move money out of your name reduces the asset pool, reduces the amounts that people can fight over. So that's one thing that people who are really headstrong about not wanting to leave something to a certain person but trying to avoid a dispute will do.
Yeah. What happens if you just want everyone to get along? I mean, probably the best thing is to involve them in these conversations. Do you have sometimes you're in meetings where the whole family is involved?
Yeah, sometimes. It really depends on the person and their relationships. Some people I see are still quite reluctant to talk about death and dying and what happens with their assets. There's a cultural factor at play there as well. Some cultures really don't like talking about dying. They think it's sort of a taboo subject or people get quite superstitious about talking about death as well. So, you really just have to respect where that client's coming from. Some people really do want to involve the whole family in the succession plan. That's particularly helpful where, for example, there's a family trust or a business or a company that they all work together in. Figuring out sort of a business succession plan which sort of works with the family's estate planning is really helpful to get everyone on board.
Yeah, and it just means that there are no nasty surprises, right? Like
That's
everyone's not waiting until the person has passed, and then you can't ask questions and interrogate their motivations. And at that point, the moment's lost. It's nice if everyone sort of you can try and preserve family relationships.
Yeah, exactly. And particularly where the parent is doing something that, might be surprising, it is good to sort of say, well, how do you think your children are going to feel about that?
Yeah.
Yeah.
And just gently sort of interrogating their motivations. And I mean, I think that's an interesting an interesting facet of your job, definitely.
Yeah.
One of the areas that you're very passionate about is helping families who have children with disabilities, because obviously that is a really complex part of your estate is working out, making sure that your kids are going to be looked after. How do you manage that?
Yeah, this is a really personal area for me. I've got a daughter with a disability, so I understand how stressful and anxiety-inducing that can be to think about their future. All parents, every client that I see, one of the hardest decisions they have to make in their estate planning is appointing a guardian for their minor children. So every client that I see, I ask, if you were to pass away before your kids turn 18, who would you appoint to be their guardian? And for most parents, that's the most difficult decision because it's thinking about somebody else having to raise or look after your kids is really difficult. For parents with kids with disabilities, that's not a decision, that's not a question that ends when the child turns 18. You need to think about who's going to look after them for the rest of their lives if you're not around. And that means taking care of their well-being, their guardianship, and also their financial future. So there's a lot to think about there, and a lot, really just thinking about who's going to step into my shoes and make sure they're looked after if I'm not around to do that, which is, a really confronting thing to think about. There are some really good measures that you can put into place for people with disabilities. Special disability trusts are a really useful structure for people with disabilities. A lot of people don't know anything about special disability trusts.
I've never heard of it. What is it?
So what it is, it's a type of trust. It's regulated by Centrelink, and it basically means that it's a trust that's set up for the benefit of somebody with a severe disability. It's designed to meet all of their accommodation and healthcare needs. So you can put funds into that special disability trust, and the main advantage of doing so is that any assets that are held in that trust, up to around $800,000 at the moment, won't be counted when Centrelink is doing their assets test.
Great.
To assess somebody's eligibility for the disability support pension. So it means that funds can be put aside to look after that person, and it won't affect their disability support pension entitlements. Huge advantage there in terms of the welfare that they can receive. And then the person setting it up can control what happens to the balance in that trust when the beneficiary passes away. So you still have that control to say, okay, I'm going to put all this money aside for my daughter to meet all of her needs. Then when she no longer needs it at the end of her life, whatever's left over can go to a charity that I support or to my other children.
Great.
So, yeah, it's a really useful structure. I wish people knew more about it.
Well, yeah, and that they just considered it, because I know when you're the parent with a child with a disability, when do you find time? These are the people who are under the most pressure at work, at home. I mean, it's hard enough to deal with the realities of the day-to-day without having to think about that stuff. But it's so important.
It's so important. And thinking about the people that you're appointing to look after the trust, so the trustee of the Special Disability Trust, who's going to be making the management decisions, investments, making money available, deciding how the funds in the trust are used. Appointing the trustee of one of these trusts is a really difficult consideration as well. I know a little while ago I saw a family who, it was just a mum and dad, 2 adult children. The adult son had a severe disability, and mum and dad had done all the right things. They wrote a will, they'd set up a disability trust in their will, they'd appointed their other son. They'd always just assumed the other son would be there to look after their son with a disability. And then the adult son was such a sad story. The adult son got terminal cancer. So the clients came to me and were like, we don't really know what to do, because he's our only other person.
Yeah.
And he's going to now predecease our vulnerable son.
Yeah.
So working through the options that these clients had in terms of other friends or family members or professional trustees that they could appoint, it can be really difficult.
So there are professional trustees. So if you have actually exhausted your options.
There are, yeah. So there are lawyers who will act as trustees of trusts. There are trustee companies that will take on that role. So yeah, there's always someone, but it's just sort of working out who the best fit is for your person.
How do you make that decision? What are some of the things that you should be considering?
Yeah, so thinking about when these trusts are set up, it has to be who's going to be around for the rest of that person's life, really. Or if they're not, who would they hand it over to?
Yeah.
That's a huge consideration. So that's one argument in favour of a professional trustee company. There's Equity Trustees, there's Perpetual, Australian Unity. There's a few out there that you're pretty certain are always going to be around. The downside of that is obviously they charge fees for acting. So you have to do that cost-benefit analysis to see whether the fees that they charge will be appropriate for what the trust is. Otherwise, there are some lawyers, so negotiating with them to see how they work, how you sort of feel like their ethics and their, the amount of care that they would take. And then, hopefully there's some other friends or extended family that can keep an eye on that.
Now, separately to disabilities, you also work with people who are caring for vulnerable family members more broadly. That's obviously ageing parents, spouses, maybe with declining health, adult children who may struggle to manage money. I think that that's a big one as well. Mm-hmm. What are some of the things that people should be thinking about before a crisis arrives when you're dealing with that sort of milieu of people?
Yeah. The first thing is to think about is none of us know when a crisis is going to arise, right?
Yep.
So I see a lot of people who think, I'm too young to deal with this. I don't need powers of attorney. That's something that only people who are old and about to get dementia need. I don't need to do a will. I'm only in my 30s. Or even I see clients who come in and say, okay, I'm just going to put this will into place now, but I'm going to come back in 10 years and change it. I'm like, okay, that's fine to do, but you could walk out of here today and get hit by a bus, or, unfortunate things happen to people of all ages all the time. And if you don't have documents in place and then you lose capacity either through, a sudden onset of dementia or an acquired brain injury, however that might arise, you lose the ability to have that say for yourself and to make those documents. So I think just putting something in place as soon as possible so that you don't lose that ability to make the documents yourself is vital, really. Just sort of as a bit of background, powers of attorney are the documents that you make where you appoint somebody to make decisions for you if you lose capacity. If you don't do an enduring power of attorney where you appoint somebody to make decisions for you about your finances, and then something happens to you, you might be in a coma, you need bills to be paid, right? You might need your mortgage to be paid or kids' school fees to be paid. People need to be able to access your accounts to be able to do that.
Yes.
And if there's no enduring power of attorney where you're giving somebody that authority, they'll need to go to VCAT to get approval. That's a stressful, long and complicated process. And, it just puts a lot of extra pressure on the people around you.
We have had someone on this podcast where their partner sadly and unexpectedly died, and there was no will in place. And some of the advice that she was given by someone was, while she was dealing with the immense shock and grief of that situation, was go to an ATM and take out as much money as you can right now because all the accounts are about to be frozen. And so her talking about the day-to-day grind of not being able to pay school fees, pick up a puppy that the family had been promised, all this sort of stuff. Anyway, she managed to pull it together, a very remarkable woman. But it is, if your family is left with this shock, it can be very life-altering in the short term financially, not just the long term, but the immediate short term.
That's right. And a lot of people don't realise as well is that as soon as, like you said, as soon as the bank is informed of someone passing away, all the accounts are frozen.
Yep.
You lose access there. If everything else is in that person's name, then you're quite stuck really about what you could do until the probate goes through. So that's another conversation that people need to be aware of that I go through with my clients is how are your assets owned? If everything is in one person's name, how is the other person going to get by while probate is going through? Because that's not something that happens quickly.
How long can probate take?
Oh, it really depends. There's a whole process you have to go through of working out what the assets are, making the application to the Supreme Court for a grant of probate. The Supreme Court in Victoria actually at the moment is pretty fast. They're doing a great job, the probate office, of turning probate applications around quite quickly, especially compared to other states. But there is a bit of legwork and administration that has to go on before you can make that application. So, yeah.
That could be like shocking, that the ramifications of not being able to pay your electricity bill, your water bill or whatever, like go buy a coffee. It's just like these are – it's crazy. And I find, really quite bad how out of lurch often women are in these situations, because women do, as we know, often leave a lot of these financial decisions to their partner if they're in a relationship with a man.
Yeah.
It's always something that we should, if we're going to be big adults, we should actually be considering sooner. One of the interesting and more nuanced things when it comes to estate planning is the distinction between estate assets and non-estate assets. What's the difference and why does that difference matter?
Yeah, so I sort of touched on this a little bit earlier. So when you die, the only assets that will form part of your estate are those assets you own in your sole personal name. They're your estate assets. Non-estate assets include anything that you own jointly with somebody else. So if I own a joint property with my husband, or if I have any joint bank accounts with anybody else, if I die first, those assets automatically go to the surviving owner. They don't come into my estate. Similarly, anything that I might own, well, not that I own, but is that I hold in a trust or a company or even my super fund, they're not assets that I own personally. They're owned by the other entity, so whether that be the family trust, the company, the super fund, business, whatever it is. If they're not assets that are in my name, they don't form part of my estate. So some people really aren't aware that their super doesn't automatically form part of their estate, or that, assets that they have in a family trust aren't their personally owned assets. So we need to do different things as part of the estate plan to work out how those non-estate assets get dealt with.
Where this can get complicated, or where I have seen it in my family circles where it gets complicated, is that you have a parent who remarries, and the family home, where people have grown up and you have a big emotional attachment to, is no longer. They expect it to come through to the children, and that sometimes isn't the case. Have you seen that?
We see that a lot. There's a couple of different scenarios that we see, and people come in and they've heard horror stories in their friendship groups or their families.
Every like I said, everyone has a horror story.
Yeah. And some of the scenarios are, like you said, where somebody remarries and then the kids are excluded, so everything would go to the new partner. Or a different scenario is where you have a blended family, so a couple comes together, they've both got kids from previous relationships. They make wills together where they both agree, yep, I'll give you everything. And then when you die, everything gets split between all of our children equally. And then when one person dies, the survivor comes in, rewrites their will and leaves everything just to their biological children. We see that a lot as well.
Oh, do the non-biological children have any rights then, or is that...
They do, but that can be complicated and expensive.
Yeah.
Anytime anyone challenges an estate, that's a huge hit in legal fees that will come out. And it's just really messy.
And bitter.
And bitter, yeah.
And bitter. And you would be feeling very bitter if that was the if that's what happened. Can you... Is there any way that you can stop that from happening?
Yeah, there is. So there's a few different strategies that we talk to people in blended families about. And also people in really happy marriages will come in and say, I've seen this happen. I trust my partner. I don't think this is going to happen, but it might. So I want to do something in my will just to protect my kids from whatever my spouse might do if I'm not around. And that's perfectly fine. I'm not here to judge anyone's relationships or anything like that. It's a perfectly reasonable thing to do, I think. One thing that we would do in those sorts of circumstances is think about how particularly the family home is owned, because if it is owned jointly between the couple, when one dies, that goes to the survivor, right? And they can do whatever they like with it. So one thing that some people might do when they're worried about this is to change the ownership of the family home from a joint ownership to tenants in common. And that's a huge distinction, because it means that the rules about joint ownership no longer apply. Each person owns 50% of the house and they can deal with their 50% in their will. And what they usually do in their will is say, okay, with that my 50% ownership of the house, I'll let you live in it, the survivor live in it, for the rest of your life or for as long as you want to. But then when you die, it's going to my kids.
Yes.
So that's sort of an effective strategy to guarantee that your kids will get a share of that asset.
And you know what? I think it's so important because it's funny. You do think you know a person. But it does change when there's large sums of money involved.
Well, also,
it's funny, isn't it?
Yeah, people are grieving, new relationships come in. You know, the stepkids everyone copes with grief really differently. And I think that's, you just don't know how it's going to play out.
It must be it must be difficult in your position, because I reckon that you would see the best in people and also the absolute worst in people.
Yeah, I do. I absolutely do. I've seen, $1 million estates where people fight and have insane legal battles over a tea set or something, something that has some sentimental value but they just can't let go of. And they fight to the, insane levels over things that really don't matter that much. That can be interesting to observe.
Yeah.
But also I also see really great things. So I have some clients who are single, don't have any children, and have accumulated a lot of wealth in their lifetime, and sitting with them and working through, what do you want your legacy to be here? How do you, you've got no obligations. You can do whatever you like with your money. Let's set up a charitable trust. What's important to you? Who would you like that to go to? And I've dealt with clients who, have set up charitable foundations or scholarships to put people through university. So that's really rewarding.
Can I have the number of the people who are single and have large trusts? They sound great. They sound lovely. I think we'd get along real well. Because I'm also single, but I don't have a large trust. But I mean, it's funny, isn't it? Because you really do deal with all of people in difficult times. You must always have something to think about, or a lot going on in your office.
That's right. Every family, as I said, is so unique and has their own stories, and it's great to hear.
Now, if you're listening to this podcast and you do actually want to listen to a story about someone who did not set up their estate properly, I do really recommend that you Google the Lara Carey case, because that's the story that I was talking about, where her husband, Ben, unexpectedly died, and then the ramifications of that for Lara, who's such an impressive woman, and how she sort of came out of that financially is really a very compelling listen, and I recommend you checking that out. Susan, you have been so generous with your time. Thank you so much for coming on the show. I learned a lot, and I'm sure a lot of people listening did as well. Thanks for coming on.
Great, Steph. Thank you so much.
And if you got something out of this conversation, and I hope you did, here's a friendly reminder to tick another thing off your admin list, and that's to follow Money and a Good Life wherever you're listening to this podcast now, so you don't miss an episode. And we'll see you next time. Advice given in this podcast is general in nature and is not intended to influence decisions about investing or financial products. Our listeners should always seek their own professional advice that considers their own personal circumstances before making any financial decisions.